please welcome to the stage Timothy Naftali.
Should I invite them to come up at the end? Okay. I'm not scripted. I'm just terribly discursive. So to keep short, I'm going to I have some prepared remarks. Welcome to another in the Institute of Global Politics Across the Aisle series. I'm Tim Naftali, a presidential historian and gratefully a senior research scholar and adjunct professor here at SIPA. The aisle in this case is a metaphor for a difference of opinion, not for a lane in Congress or a chasm between presidential administrations. Sometimes the aisle is narrow and sometimes it's broad. It will be up to you in this room and streaming and our wonderful panelists to determine the scale in today's topic of conversation. Debates over the appropriate ambit of presidential power are as old as the Republic. Thomas Jefferson attacked our second American president, John Adams, for being a king or dictator. Arguably, in the 19th century, our best president, Abraham Lincoln, joined a new party, the Whigs, which was formed in reaction to the actions of King Andrew I, otherwise known as Andrew Jackson. Inspired by a British party that believed in the supremacy of Parliament, American Whigs worried that Jackson's conception of the presidency undermined the power of Congress. In the nuclear and post-9/11 eras, debates over the American presidency reflected debates over the direction of a global superpower. And the reference point for critics was the idea of the imperial presidency. These debates are as American as Bad Bunny and apple pie. And today we are very lucky to have three extraordinary people to walk us through the current moment in this national conversation and its constitutional and historical antecedents. Tom Lee is Leitner Family Professor of International Law at Fordham Law School. Professor Lee, who clerked for Justice David Souter of the Supreme Court, served as an active duty U.S. naval cryptology officer. He was Special Counsel to the General Counsel of the United States Department of Defense in the first Trump administration. Gillian Metzger is the Harlan Fiske Stone Professor of Constitutional Law at our law school here at Columbia. Professor Metzger, who clerked for Ruth Bader Ginsburg, Justice Ruth Bader Ginsburg of the court, served in the Department of Justice's Office of Legal Counsel in the Biden administration as Deputy Assistant Attorney General and as Acting Assistant Attorney General. And our moderator today is Matthew Waxman, the Liviu Librescu Professor of Law, also at Columbia Law School. Professor Waxman, who clerked for Supreme Court Justice Souter, served as Deputy Assistant Secretary of Defense, Director for Contingency Planning and International Justice at the National Security Council, and as Executive Assistant to National Security Advisor Condoleezza Rice in the George W. Bush administration. I mentioned that each clerked for a Supreme to underscore how privileged we are to have these individuals here to discuss the Constitution and the presidency. And we are also privileged to have all of you. Thank you for being with us today. Matt, I'd ask Matt Waxman, Professor Lee, and Professor Metzger to come to the stage. And Matt, once he gets up to the stage, sits down, gets comfortable.
Look at both of you.
The panel, Matt, is yours. Thank you very much.
Great. Well, thank you all for coming. Let me start actually with Gillian, and then I'll ask the same question of Tom. I think Tim talked about the roles that each of you played in the executive branch as a lawyer. I think it would be useful for each of you to talk a bit about what specific role you played as a lawyer. And let me ask what I think is, in some ways, a very basic question, but in some other ways, very, very complex, which is in those lawyering positions, who was your client? How did you think about who you were representing? And most likely you played sometimes a role of advocate, sometimes a role of advisor, sometimes a role of arbiter of the law. And I imagine there were conflicts or tensions between those. How did you think about the combination of roles and how to mediate those tensions?
Great, thank you. So it's great to be here, and thanks to Tim for the introduction. So I, as Tim mentioned, I was at the Office of Legal Counsel in the Department of Justice. And it's known as OLC, and it surfaces occasionally in the papers, but it's basically the legal advisor for the executive branch. It's different from the general counsel of an agency where you're really just counseling that particular agency on legal questions. Instead, agencies come to OLC to have questions resolved. The White House counsel comes to OLC with legal questions, and the Attorney General and the Department of Justice come to OLC. So you could say, in some sense, that when an agency comes to OLC to have a question resolved, the agency is the client. I think that ignores some of the special things about OLC's role. We are, in that sense, sort of answering a question somebody has asked of us. Sometimes we're asked to literally adjudicate a dispute between two agencies, so it would be odd to think about it as being the client. But in addition, what OLC is exercising is the authority of the Attorney General by statute to provide advice on legal questions. And so in another sense, you could say the Attorney General, in some ways, is the client. And then the real complication is sort of how OLC talks about its role and ideally is supposed to perform its role. Whether or not it does is a matter of some debate, which is really to act independently and offer the best view of the law as OLC sees it. And in part because we are using the Attorney General's authority, OLC's determinations, legal questions, supposed to be binding on the executive branch. They can be overturned by the Attorney General or the President. So all of that makes the idea of having a client complicated. That's not the usual kind of client relationship you'd have. You could say it's, as I said, the agency or the AG. You could also say it's really the idea of government under law, that in the ideal version is the client that OLC is seeking. And so you really have to navigate those roles. And one of the things that, one of the ways that happens is there are different ways advice is asked of OLC. So sometimes it's more formal, and there's a more formal written opinion. Sometimes it's more informal, and so there's more ability to sort of have sort of give and take. And one of the things that you try to do is if the way that an agency wants to go about taking some action, it's hard to find the legal authority for them to do that, or it might raise legal questions. Help them think through another way, another alternative to get to the goal that they want that would actually be lawful. And that is what is a good part of what OLC's counseling will do. That said, part of what OLC has to do is be willing to say no, and to question the legal justifications that are being brought to it, and in particular be willing to question some of the factual assertions that it's being asked to decide on the basis of. If it doesn't do that, it's not really serving the special purpose that it traditionally is supposed to play.
So my answer is even more complicated than Jillian's, because the Department of Defense or the Department of War, there are 12,000 lawyers there. It's a sprawling agency. It's the largest agency. The budget is more than $1 trillion. And so it's a more complicated answer. But what was my job? So right after 9/11, the first person to hold this job of special counsel, the general counsel, was a man named Jack Goldsmith, who is now at Harvard. But after 9/11, the Pentagon thought, well, we have all these new issues in international law of armed conflict, U.S. foreign relations law. Wouldn't it be really nice to have some academics think out of the box, come in here and be sounding boards rather than having the homegrown advice dominate, because these are really important issues. We need creative thinkers. And so Jack Goldsmith, under the General Counsel Hayes and Secretary Rumsfeld was the first person to sort of hold this position. It's been gapped sometimes. It's not technically a political position, so you don't have to go through the type of screening you would for a political position, but generally they look for lawyers for this position who have academic backgrounds, but not just academic backgrounds, have some practice experience, depending on, particularly for that job, really would like military experience, because the military culture is very different from the civilian culture, and it helps to have that. So that was my title. I will say I was hired under Secretary Mattis, who I knew not very well, like many people knew him very slightly. But by the time I got there, he was gone. I had not actually interviewed with the Senate-confirmed General Counsel, and he was there. And so no one knew who I was, really. And so it was an interesting first couple months, because no one trusts you. So they're sort of, okay, go color some crayons, file some reports or whatever, but we're not gonna really use you. And so what happened was, ultimately over a series of issues, I sort of gained the General Counsel and the Secretary's trust. And so at that point, as often happens in the military, when they find someone who can actually do stuff, you end up doing too much, right? And it was an extremely eventful year. The first impeachment, the Soleimani killing, COVID, Black Lives Matter, National Guard deployments in various capacities. And I sort of had a seat right at the table. I mean, not necessarily like a primary player, but sort of sounding off on all of these things. And Matt's question was, were you an arbiter? Were you an advisor? Were you an advocate? I mean, it was really a lot of all of those things. So if you had a dispute between services about something, the General Counsel's office would be, its lawyers would deploy to help resolve these situations, right? So there was one involving the Army Corps of Engineers and the definition of navigable waters and things like that, and there was a difference of opinion. There were issues involving, I'll give you a classic example, because I saw it was below the fold news in the New York Times today about the Stonewall monument, LGBT, the gay pride flag being taken down. So we had that issue, not the gay pride flag, but after Black Lives Matter, there was a movement to take down the Confederate flag, right? And not officially on bases, but some people would have them on base housing and so forth. And so it's a tricky issue. It's Trump administration won. The Marines had actually rolled out a ban the Confederate flag memo, and I love the Marines, but it was kind of classic Marine, hadn't thought of all the different issues and First Amendment implications. And so the lawyers said, well, why don't we try this? Why don't we write a memo that lists the flags you're authorized to fly, and if you're not on the list, then you can't fly it, right? And then it goes, and everyone's like, well, what about my sports team, the Seattle Seahawks, or whatever, or my college team, of base housing? No. This is the only list of flags that you're authorized to fly. And so it was the lawyers that created the space to be able to announce a policy that wasn't going to offend the White House too much, that was going to achieve the objectives. Now, a policy is the right one when the Biden administration comes in and they keep the policy on flags. Now, the other departments had sort of gotten into banning and prohibitions and so forth, and that gets you into trouble, because at some point you're going to have to draw lines. And so what we're seeing is sort of the Times coverage had a certain view of the policy. I mean, it's particularly poignant because Stonewall Monument is about the LGBTQ community, but that's sort of a flavor of the type of things these lawyers would do. The other, as an advocate, the Department of Justice, which Jillian served in, is the litigating arm. So we don't, except for the military justice system, and we had military justice system issues too, for example, reforming the prosecutorial system about sexual assault and creating the office of this special prosecutor. That was all going on too. But the Department of Justice is the litigating arm. And so when we deal with cases, and I dealt with just a variety of interesting cases. Then you shift into sort of in-house lawyer mode. And the Department of Justice lawyers are your lawyers going into court. We'd have arguments, right? Particularly FOIA litigation on what should be disclosed or not. I mean, the White House and the executive agencies have a very, very robust understanding of that. And then a lot of those times we'd have phone calls with OLC lawyers to get their chiming in. And at that point, the head of OLC was a man named Steve Engel, who was my friend who I'd clerked with. He'd clerked for Kennedy when I clerked for Souter. So that made that interaction much easier and getting to consensus. And so, but they're the ones who litigate the cases, and we would review briefs. If we needed depositions or Vaughan indexes, something you have to prepare for FOIA litigation in the building, I would supervise, or the lawyers we would supervise the production of those materials for the Department of Justice, but they're the advocators. The final thing, the interagency, I mean, obviously the Pentagon, the most important, strike that, maybe not the most important, but one of the key things, they're the ones with the military options. So if the president is considering a situation and says, I want some targeting packages developed, and I want them, the lawyers scrub them for legality, and they're presented the National Security Council and the legal advisor of the clearinghouse for that, right? And so oftentimes, again, OLC interacts with the Pentagon lawyers when they do the legal scrub, once the targeting packages, once the operators have come up with the targeting packages, and they're being presented to the White House as options. So that's my last point, because one thing about being a Pentagon lawyer is, who is the client? Of course, the client is the United States at the end of the day, but you have as clients the operational people in the building, but ultimately you also have the warfighters, right? And it's really hard for someone who's a pointy-headed lawyer not to defer to the warfighter, because they're putting their lives on the line, right? And so when the operational planning happens, you'll often see a lot of deference to the operators who are actually going to have to conduct the missions, right? And that's something that I think is a special feature of being a Pentagon lawyer as opposed to a lawyer at Department of Justice or the State Department.
So Tom, let me stay with you for a moment. I have a question, and then I'll give Jillian the opportunity to give her perspective on it. The modern presidency is often described as imperial. That's often sort of a critical word that's used. I think another word might be energetic, the modern presidency. And sometimes that's defended as necessary in order to deal with modern day challenges. I think critics would say that an imperial presidency, an energetic presidency, risks eroding the kinds of checks and balances that the framers of the Constitution originally envisioned. Could you give your take? Should we think of the modern president as imperial, and is that actually a good thing or a necessary thing?
So I prefer the adjective energetic, right? Because I think it's perhaps less pejorative. The one thing I'll say is, if you look through history, and Lincoln is the prime example, and you've written about the prize cases, I've written about the prize cases, you do see in a lot of situations the president exercising sort of a move-out energetic kind of role. And I guess in the early period, it was justified on the basis of just the technologies of communication and the reality of the fact that Congress wasn't in session a lot and things would happen and you'd have to move. And that's certainly the situation with President Lincoln's declaration of the blockade in April, while Congress was out of session in 1861 after Sumter. And now, obviously, you do have technologies of communication. You do have sort of instantaneous consultations. So it's not necessarily a physical restraint, but the president is engaging in a lot of actions that are without consultation of Congress, arguably, or consultation in a broad sense, as opposed to members of your party. And I think that I think I see that that's problematic, but I feel like in today's world, it's also kind of necessary for a lot of issues. And the issue I was thinking about was, I was there for Operation Warp Speed. I mean, that was a monumental act of leadership by President Trump. No one thought that an mRNA
Could you remind people what that was?
Oh, I'm sorry. That was the development of the mRNA vaccine. You know, we were at meetings and like, it's going to take 5 years, 10 years. You know, we have to do it this way. And President Trump, to his credit, said, we're the United States of America. We could do it in 1 year. Let's throw, you know, a 4-star general, the head of defense logistics. Let's use our authorities to sort of bend the arc of production in private sectors to move it this way. Let's just throw tons of money at the problem. And I can say, I mean, this is all publicly available, no one thought that was possible. And it was, right? I mean, it's ironic that in today's political environment, he can't claim credit for that monumental act of leadership. But like in some sense, and it was interesting because with the deployment of the vaccines and requests for National Guard and hospital ships, it was interesting to observe that whole process happening. So I think that that's sort of an example of something where the energetic president worked. Now, it's much more complicated in foreign affairs, right? It's much more complicated in foreign affairs. And that's sort of my specialty, but I will say this, right? We sort of lived in a world where the international law governing and the US law governing the use of armed force was portrayed as restrictive of what the political actors in the United States can do. And number one, like my own scholarship focuses on the fact that that's actually not true. Law is much more permissive, including international law. And the reality is, from a lawyer perspective, if the drift between where law and politics becomes too great, then law, especially in an environment where international law, where you don't have any uncontested institutions of final adjudication, it's going to become irrelevant, right? And so there are a lot of people on the right who feel like international law, United Nations, I don't have any use for these things. I'm not one of them. I believe in these institutions, but I'm also someone who says, like, look, we can't have a conception of law that says no all the time. And that's not, in fact, the conception of law. So,
Jillian?
Sure. So I'm a little bit less sanguine on, and I would actually not equate imperial and energetic. When part of what I think we have to do here is really be careful and analyze what is the nature of the claim of presidential power that we're talking about. Are we talking about inherent presidential power granted directly by the Constitution or implied in the Constitution? Or are we talking presidential power granted by virtue of a delegation of authority by Congress? The warp speed, Operation Warp Speed, right, was often using delegated authorities as opposed to inherent authorities. And that makes a difference because, you know, one of the situations that we're in right now is in a world of tremendous delegations of authority. And too often, that is often seen and viewed as the president exercising inherent authority. But delegated authority from Congress means Congress can also limit it. And the question might be whether or not Congress has imposed enough limits, whether we've got enough accountability. It's not inherent in the president. And there are certain kinds of powers that the administration is claiming right now, for example, over the power to impound funds or to control spending or to dismantle agencies. To just talk about some domestic ones, there's also, of course, the bombings in the Caribbean and other actions. But a lot of the powers that the administration has been claiming are actually powers of Congress and core powers of Congress. And I do think it's really important to make sure that we don't take the idea that the president has to be able to exercise those powers as sort of necessary to have an energetic president. The other reason why I'd separate out the two is because you can have an energetic president who is simply executing the law laid out by Congress and doing so vigorously. And in fact, historically, there was a desire for much better execution of the law at the time among the framers. But that didn't mean that they wanted to necessarily give the president a lot of inherent authority. There's a tremendous debate about what does executive power mean. Does it just mean the power to execute the laws that are created by Congress, or does it also contain a grant to some kind of implied inherent powers? And so it's very important. If you push more on the inherent implied, then I think you are going to a much more imperial presidency, in the sense of it's very hard to rein it in as a matter of legal controls. This is all, however, on some level a little bit abstract, because the reality is that the president has tremendous first mover advantages. And so the historical practice has been for more and more assertions of presidential authority. And that has been true since we've had administrative state and delegations of authority, because those give more means to the president. And as a result, when we're thinking now about the energetic president or the imperial president, one of the things that's most important is to think about what are the checks within the executive branch that are pushing back on those exercises of authority. It's going to be for various reasons we can discuss, Congress is not as active and is unlikely to be as active when it's of the same party as the president. But you have an executive branch which was constructed with a number of means of protection and expertise, independence, procedural requirements, all of which are ways of channeling grants of authority that the executive branch can read, subject to the president's supervision, in ways that are more accountable and more lawful. And what is particularly troubling today, and it pushes more towards the idea of it's imperial, is the suggestion that those constraints are unconstitutional, which we hear from the current administration. And so again, that's an instance of a kind of claim of very, very broad imperial Article 2 authority, Article 2 of the Constitution authority, that I would really push back at, though it doesn't mean that the president doesn't exercise a lot of delegated authority from Congress.
Jillian, can I stay with you for a moment and ask you to elaborate a bit more on what's so new here, right? If one were to think about assertions by the Trump administration or by President Trump himself, assertions of very broad inherent executive branch or presidential powers under Article 2, or very capacious interpretations of delegated power. I think a lot of critics would say that's what modern presidents have been doing for a long time. Given that most modern presidents have interpreted either their inherent power or their delegated power quite broadly, where do you see this administration legally really breaking from that past pattern, as opposed to just carrying it forward?
It is absolutely the case that there, as I said before, a trend towards greater presidential power, and you see it across administration. I think they're both domestic and international examples. So on the international, I think the bombing in the Caribbean is something new. I think that kind of equation of what's really, in the justifications I've heard, a law enforcement endeavor, and using the military in the way that it's been used, and some of the allegations about particular actions, strikes me as unprecedented. This is more, I will confess, your guys' area than mine, but I find that to be a step beyond what I would have seen before. On the domestic side, we're seeing a great deal of assertions of authority that in the past you did not see. And I think the prime example here is the impoundment and what's happening with the grants cancellations and the appropriations power and the efforts by the administration to stop paying out on grants that have been granted or impound funds in various ways. And this goes back to the first Trump administration and arguments by members of that administration who are also in this one, to the extent that the president has some kind of claim of inherent authority over the power of the purse, which is, I think, unprecedented and also wrong as an interpretation of the Constitution. Similarly, the idea of dismantling government, the use of the National Guard. Obviously, the National Guard has been called out before, but the way it's being used to target blue cities, blue states, and against the wishes of the governors, I think is something new. So I think we're both seeing, some moves maybe taken a little bit more intensely, but we're also seeing new kinds of assertions of authority that we haven't seen.
Tom, that raises a couple questions I could pitch to you. You are a specialist in, among other things, presidential power to use military force, something that Jillian just referenced. When it comes to the use of military force, both domestically and abroad, there are a lot of precursors, if not precedents, that President Trump could point to. To what extent do you see the current kind of suite of actions as either carrying on past precedent or exceeding it.
Yeah. Before I respond to that question, I'll just say to Jillian, I don't disagree with Jillian about the basics in terms of the distinction between delegated and I wouldn't use the word inherent, but kind of powers that the president through whether based in text. I'm not sort of an executive power textualist, but through practice or whatever that the president has the ability to do. So I agree with that, and obviously a lot of what was happening in Operation Warp Speed were pursuant to delegated powers, although delegated powers exercised in ways that had not been exercised in quite some time. I also agree with you about the internal checks and balances, and I think that perhaps observing from the outside this time what's going on, I think that seems to be somewhat different from the first administration, where the process, the interagency process, and sort of the internal checks function pretty much how you would expect them to function in any, during the Biden-Obama administration or Bush, the younger administrations. And it does seem that that process is not functioning quite as robustly as it was. So I'm not disagreeing with you. On the new uses, I'll refer you, number one, to I have a Bloomberg column, and I published one on the Venezuela commando raid and one on the possibility of invading Greenland. So I'm going to refer to the analysis I put in there. I have one forthcoming on Iran, so when that comes out, you can look at that. The National Guard deployments, I was a part of that for not for January 6th, but for the Black Lives Matter protests. That authority is tricky, and it's not to say that the extent to which it's been deployed this time around may be outside of reasonable parameters, but there is a much stronger legal basis in authorities in the president's protective power there than people, the commenters, realize. So I'll refer to the record on my thoughts about the Venezuela commando raid and Greenland, and also state there. The general comment I'll make to you, Matt, though, is, and this is on the international law side, it's really about avoiding great power conflict and the deployment and the use of nuclear weapons and genocide. I mean, really, the UN Charter's use of force prohibitions at core are, let's make sure that the Great World War from 1914 to 1945 never, ever, ever happens again, right? And as a historical matter, there have been lots of little conflicts on the margins and so forth. On the US law side, the test has become really, really flabby. I mean, it basically is a two-part test that says, are there any US national interests? You could drive a truck through that factor. Like US national interest, anything pretty much counts. And then the second factor is it war in a constitutional sense? And really, that has come to a calculation of how many boots on the ground, how long are warplanes feet wet over target, how much munition are they expending, how many days is the operation, and on the U.S. war side, the test has become, flabby, right? But you're a government lawyer. You have warfighters who are going to have to lay their lives on the line. The White House is telling you, we want military options, targeting packages. That's the law you have, right? And you try to do an honest job of running through that law. But it is extremely permissive. Putting my academic hat on, I'd like the world to follow me and sort of come up with a more restrictive formulation of that, because as someone who's originalist sympathetic, I don't think that this is a world that two-factor test is faithful to the Constitution's original blueprint in some fundamental way. But as a lawyer and as a government lawyer, with the client being the United States and the warfighters, I mean, that's the test.
Tom, can I stay with you for a moment and talk about another critique of the Trump administration, and really the Trump presidency? And I wanted to draw a sharp distinction between the two. One of the critiques is that President Trump has not just centralized a lot of power within the executive branch, but really within the president and the Oval Office. I'll give a couple of examples. One is the reining in of so-called independent regulatory agencies by asserting the power to fire regulators kind of at will. Another example would be controlling criminal prosecutions and actually dictating some of the activities of the Justice Department that would normally be done at some distance from the White House. Now, one of the answers or one of the justifications for this sometimes goes under the nomenclature of unitary executive theory, an idea that Article 2 talks about not vesting the executive power in a presidency or in an executive branch, but in a president. What is the best case? What is the best case that one could make, constitutional case, that the president does have the power to take these kinds of actions, to centralize them within the Oval Office?
Mm-hmm. I have to confess, again, I'm a use of force person, and again, I'm not in the administration, but I think that you're right, Matt, that we're seeing a degree of centralization in the Oval, right? And I mean, at the very inner circle, that is, I don't want to say unprecedented, but really centralized. I mean, the centripetal forces are undeniable. Is that degree of centralization contrary to the constitutional blueprint, the constitutional framework that was established? Just as I sort of softly suggested to you that the two-factor test may be inconsistent with the constitutional blueprint. I don't want to get in trouble, but I think yes, to some extent, right? I mean, I'm not a full-throated believer in the unitary executive theory, but at the same time, I'll say that the world today is so different. It's so much more complicated. I don't know if that's a clear answer, but yeah, I mean, I think that the unitary executive theory is somewhat problematic from that respect. I mean, I could certainly see the perspective of the White House being in the first Trump administration. There were policy initiatives that were clearly good to go, that should have been green-lighted, that should have happened quickly, and people dug in, right? And so I could sense the frustration and saying, look, that's not how it should be. But in trying to correct this time, I feel like there has been too much overcompensation, and you're losing people who are not part of that problem, who have real expertise, who love the institution, who are good Americans, and that's troubling.
Can I ask you if you want to comment on that? Yeah.
Sure. I'm with Tom in not being a unitary executive theorist. I think both as an original matter and as a matter of historical practice over time, the theory just doesn't match on the nature of our government. So if you go back to the founding, there's been increased historical work showing how many different forms of independence, different kinds of independent commissions, the Sinking Fund and Revolutionary War commissions, all of these had some kind of independence, different ways that terms of office were understood. So there's a long historical tradition of some forms of independence in the government. Of course, our historical practice has been, since we've built out the modern administrative state, independence has been a core part of that. The civil service goes back to the late 19th century, but the 1885 Pendleton Act, and any number of kind of term protections that have existed over time. So as a matter of the kind of two main sources that you would look at, I also think the text is very much available for an interpretation that supports independence. I don't see the legal basis for it. What the Constitution does do is quite clearly give Congress the power to structure the government and to structure the executive branch. And so it isn't simply that the president is taking authority or asserting authority that isn't clearly in the Constitution. It's also at the expense of the branch that does have the authority. So I think it's pretty specious. That said, the United States Supreme Court doesn't see it that way. Under Chief Justice Roberts, the Supreme Court has dramatically expanded its understanding of the unitary executive and of the restrictions on Congress's ability to provide for independence, and the president, viewing the president, again, ahistorically as sort of the accountable, the elected official who therefore needs to have chain of command control over all of the executive branch. And I think we're really seeing the Trump administration grab onto that and run with it in some very troubling ways right at this point. And one of the, you had asked me earlier about unprecedented. One of the other instances, which I think really is unprecedented and quite troubling, is this use of government power for sort of personal retributive efforts, right? So the idea of prosecuting your enemies, and that is also something that goes against. Not to say we haven't had a history of it. We certainly have had a history of it, right? Nixon calling out the tax files and others before him. But something that our norms had really shifted against, and certainly never as overtly as we're currently seeing. And that's something else that is a new use of Article 2 authority.
Go ahead, Tom. Yeah,
I just wanted to clarify, like, a slight point of difference with Jillian on my objection to the unitary executive theory. I understand everything Jillian says. My core objection to the unitary executive theory is when the is based on some other work I've done on the judiciary power. When the Constitution says, here's the legislative power, here's the judiciary power, here's the executive power, the whole theory presumes that these are, it's like a mathematical equation. There's no overlap. That the executive theory is the executive, this judicial. That just wasn't true, right? And so in work that I've done with John Golden of Texas, we've written a series of 3 articles. We talk about how the judiciary power, like, the federal government in its early days was shorthanded. They had judges looking at patents. They had secretaries, the state looking at patents. I mean, these were shifting shapes. And so for someone to say, from a sort of an originalist perspective, that there is something that's the executive, there's something that's the judiciary, and there's something that's the legislative, and that's the final word, I mean, just seems to me unrealistic, outrageous, and ahistorical, right? And so that's my objection to the unitary executive theory. But sorry, but I just wanted to clarify.
Yeah, no, that's good. And Jillian, if I could ask you to maybe expand a bit on what you said about the Supreme Court, because I'm interested in hearing more about the extent to which you think the current Supreme Court, the Roberts Court, has sort of greenlit some of what we're seeing from the Trump administration. And I would just add to that mix, just to flag a couple of other things that I heard you referencing. One is a distinction here between constitutional law and presidential norms, right? Because one of the things we hear about a lot is the President Trump eroding certain norms, right? An example being presidential interference in decisions about whom the Justice Department ought to prosecute. To what extent is that a constitutional legal issue, or is that a norms issue? The other institutional actor you referenced, but we haven't really talked very much about, is Congress, right? If you go back to Madison, a basic idea of separation of powers was you set ambition against ambition. The expectation that, all right, the president might assert quite a bit of power, but you can expect the other branches, like Congress, to jealously safeguard their own power. I think one of the things that we're seeing now is not a lot of pushback from Congress. So maybe you might comment about that as well, if you're talking about the judiciary, but also add to the mix Congress as a check.
We're happy to. I think that the Supreme Court has actually greenlit in some important ways. In some cases, it's pushed back a little bit, but for the most part, greenlit. And let me give two major instances. One is, I was talking about independent agencies. And going back to 2010, so well before Trump was on the political scene, because it actually goes back to the Reagan administration in the 1980s, this view that protections against removal, particularly for principal officers, are unconstitutional. And so again, this is reflecting this idea of a unitary executive power. And the president, therefore, should be able to fire at will principal officers and others in the executive branch. And on the Supreme Court, Chief Justice Roberts, Justice Alito, Justice Kavanaugh, and Justice Thomas in particular, are all pretty strong executive power people, and people who were in that Reagan administration and its Department of Justice that was pushing very strongly on unitary executive theory. And so going back to 2010, they have been pushing back the idea that Congress can impose removal limitations on officials in the executive branch. And the sort of case that sort of really pushed back on this was one called Sailor Law, where they invalidated protections for the head of the Consumer Financial Protection Bureau, and that was in 2020, I believe, 2019, 2020. And so, the Trump administration comes in and it basically removes from office a whole bunch of people, Democratic members of independent agencies, the NLRB, the Merit Systems Protection Board, the Consumer Product Safety Commission. I mean, you name your independent agency and they've removed the Democratic members of it. Frequently, these members would go into court and get district court injunctions against their, allowing them to continue in their positions. Appeals courts would uphold it, and then on the emergency docket, the Supreme Court would grant a stay. And it made it quite clear from those stays that its view was that these removal protections were unconstitutional, except maybe as regards the Federal Reserve. And so, that was just a case where I think the administration correctly read where the court was going and went whole hog down that route. And there are real consequences to that. I mean, one of the reasons why the administration was able to dismantle the Consumer Financial Protection Bureau was because the court had struck down the independence protections for the director. So that's one area. Another decision that I think is very important is Trump versus United States, which is the decision that granted President immunity from criminal liability. And part of it is the problem of how that decision was reasoned, which was very, very broadly, but in particular emphasizing at the outset that the president is absolutely immune whenever any exclusive or preclusive presidential authority is involved, and then further saying that prosecution and investigation are such exclusive, preclusive presidential authorities. Both of those are very dramatic moves. It's a very poorly reasoned decision and came in for a fair bit of criticism. But the idea that prosecution and investigation are exclusively presidential authorities that the president can use and never be held to account for, no matter how criminally it's used, is what I think is behind a good deal of the abuse of criminal prosecution and investigation. One of the important open questions, not resolved by Trump versus the United States, although there's a debate about what its implications are, is whether or not that decision also immunizes lower down officials. So the president can't be criminally prosecuted for trying to prosecute Jim Comey, but can the Attorney General? And that's going to be a very, very important question for whether or not we're able to cabin these kinds of powers and keep them within sort of legal constraints. So, and that said, the court has also, in some important cases involving the National Guard and some involving deportation, pushed back on the administration. So it hasn't been entirely unilateral, but for the most part, and pretty heavily on the emergency docket, they've gone ahead and supported what the administration has chosen. In terms of Congress, part of the issue with Congress is, of course, polarization and party. The framers weren't really great in predicting parties, and not surprisingly, Congress led by Republicans when there's a Republican president, just as Congress led by Democrats when there's a Democratic president, is not going to push back very much. What I think is interesting is that we're seeing pushback instead from Democratic states, Democratic state AGs, who have much more incentive to. They can't legislate, but they can litigate, which is what they've been doing. And I also think, we need to maybe move away from what we think Congress should be doing. So Congress is, in some ways, it's very interesting that the proposed budget measures, they actually, on a bipartisan basis, put back a lot of the funding that the Trump administration had cut. And we're seeing right now efforts to use the funding mechanism as a way of pushing back on some of the ICE stuff. We'll see what happens out of that. So we might be seeing, if we look not in the idea of sort of big hearings or big legislation, but look more in terms of funding and other kinds of controls, we might be seeing a little bit more develop of pushback, but I think it's really wait and see, probably unlikely under a unified government.
We just have a couple minutes. Tom, did you want to add anything to that?
No, I mean, I wouldn't call it a more charitable view of Trump versus the United States, but I think that the basic framework, core powers, president is immune, unofficial president is not immune, there's a big gray area. I'm more sympathetic to the general approach. I mean, the opinion is overwritten. Didn't see when I tried to train my 1Ls in law, I said, like, look, what am I trying to make you do? I'm trying to help you see around corners. That opinion really didn't see around any corners, and sort of is written in a very unfortunate fashion. But on norms versus law, the point, which was your basic question, Matt, like, I think that, like, people overestimate how much law actually says, right, and how much law constrains, and how easily good lawyers can work with what they have. And norms are extremely, extremely important. There's so many instances, even in the military, right, like, where they have an instruction for everything. And you look, and you don't have a rule, you don't have a law, you don't have an instruction, you're relying on a norm. And when you have someone or people who are not interested in playing by their norms, there's just a lot you can do. I mean, it's just the way the system is structured. And I think the answer, I think people just need to be more engaged. They have to understand this. I mean, it's like civics 101, like, elections matter, have consequences. And the system is built on, even for lawyers, is built on norms rather than law in a lot of places that you don't expect.
That brings us almost to the top of the hour, to the end of our program. I want to thank IGP for sponsoring this. I hope that whatever one thinks about the current political environment, this leaves the audience better historically and legally informed. I also want to thank Tom and Jillian, not just for being here today as part of this discussion, but also for their honorable service in government. I think one of the lessons I hope the audience takes from this is an appreciation for the importance of honorable service by lawyers to make our constitutional system run effectively. So thank you both very much, again, for your time here, your insights today, but also for your service. Thank you all.
Thank you, Matt.
Thank you.